Well, drug possession is defined under Mississippi law. If you look at a case called Hamburg v.State, I think it's from the 1970s, if I'm not mistaken, and it defines possession as exercising dominion or control over something. You have two types of possession. One, you have constructive possession. So if I have, let's say, a joint sitting in the center console of my friend Steve's car and I'm driving it, well, there's an argument that I'm constructively possessing it, but you still have to show that I exercise some dominion or control over it. And then you have actual possession where I'm walking down the street and I got a joint in my pocket. And that's the legal definitions of possession. The way most people get caught with drug possession is either they smell like weed. The olfactory senses don't work quite the same if you've been around it a lot as if you have not been around it a lot. So they get caught on that. And then the second thing is they admit to having it on them. Very rarely, unless you're talking about drug trafficking, some serious amounts of stuff, have they been watched or something like that. And if the feds are watching you or the state's watching you or they have an undercover agent or maybe they have a confidential informant, something like that that kicks in, those are much more common in the much larger cases than what you see is you're just run-of-the-mill misdemeanors or what I consider a low-grade felony. A felony is always serious, but somebody that's looking at a couple of years and probably some pretrial diversion as an option versus somebody that's looking at 20 or 30 years in prison is a hell of a different thing.